Hello, everybody, and thank you for joining us again for another one of our free educational seminars. As you know, we mostly have our medical specialists present, but every so often we get one of our wonderful lawyers that works with us. And today we are very lucky to be joined by Kathryn Townsend, who is, pardon me, is the National Practice Lead for asbestos and dust diseases at Shine Lawyers. Now, Kathryn's been with Shine for more than 5 years, but even before she came to the personal injury space, she has always been passionate about looking after the underdog, about human rights and about social issues. So we are absolutely very proud to have her present on this very topical and very interesting subject today. May I ask that you please keep yourself on mute during her presentation so that noise from your workplace or home doesn't interrupt or in any way disrupt the recording of the session. At the end of her presentation, there'll be the opportunity to ask questions. And of course, you can always type questions into the chat if you have to leave before the presentation is finished. Afterwards, you will receive the recording and the slides via email, hopefully by the end of today, but possibly tomorrow. You can always watch any of our presentations on our YouTube channel by doing a Google for Medico-Legal Assessments Group YouTube, or from within your MAG login on the menu button down the side, simply clicking on Educational Seminars. So without further ado, I will hand over to our wonderful guest presenter today, Kathryn Townsend. Thank you very much.
Thank you, Michelle. I'd like to begin by acknowledging the traditional owners of the land I'm presenting from today, the Wurundjeri Burra people. I'd like to pay my respect to their elders past, present and emerging. And I'd also very much like to thank MAG for the opportunity to speak to you all today. This is an area that I'm very passionate about, and it is an emerging area, particularly in light of the recent judgment that's come out of the Dust Diseases Tribunal. So the focus of today's my discussion today is, as you can see, it's going to be on coal mine dust lung disease and litigation in that space, particularly with a focus on the recent decision in the matter of Keogh and CPB Contractors, which is a recent claim that myself and the team here at Shine were lucky enough to be able to represent Mr. Keogh in a trial that ran in April in the DDT, and the judgment that came down in July. So I'm going to tell you a little bit about the case and sort of the background to it. And then I'm going to move into discussing some of the critical legal issues that were canvassed by the decision, including managing damages and cross-jurisdictional claims that have different damages regimes, entitlements to damages for care and assistance under the workers' comp regime in Queensland, and some of the implications this decision has on that. The concepts of divisibility and indivisibility, which people who work in the dust diseases space will be very familiar with, those concepts. And there was some extensive discussion on that in this judgment. And also a little bit about liability in coal miners' case and breach of duty of care. So before I jump into talking about the legal ramifications of the judgment, I want to tell you a little bit about Craig. So Craig worked as a coal miner in Queensland. He worked at the Poitrel, Morvale and Blackwater mines, as you can see, and also in New South Wales at the Boggabri mine. And he briefly worked at mines in WA before he came over and started his coal mining career in Queensland. But that period was actually found to result in no exposure of any significance, and no exposure of any significance. Craig was diagnosed with black lung in October 2018 and at 47 years of age. Now, as a consequence of his diagnosis, he's been unable to return to coal mining or any other dusty environments because of that diagnosis. The medical evidence suggests in cases of Craig's type, when people have those sorts of diagnoses, that they need to avoid any further exposure to dust. So he wasn't able to return to the industry that he loved. And, Craig loved his job. He was really, really passionate about coal mining. And that's something that really came out in the evidence and also was really reflected in the judgment, where Judge Russell did observe that he became very animated speaking about his job. And it was really apparent that he was a man who'd found his ideal job and his ideal career, and all of that was taken away from him when he received this diagnosis. And the claim was brought in the Dust Diseases Tribunal of New South Wales against his employers and the mine site operators concerning the Queensland and New South Wales coal mining work. So what is a coal mine dust lung disease? So that's a collective phrase, right, that speaks about a number of different conditions that can fall under the umbrella, including pneumoconiosis, and coal workers pneumoconiosis, which is black lung, mixed dust pneumoconiosis, and silicosis. It can also include chronic obstructive pulmonary disease and emphysema and cancers. And that's a few of the conditions that fall within the umbrella term that is coal mine dust lung disease. And I see I've sort of already jumped the gun on my PowerPoint when I've said what happens when a coal miner is diagnosed with a coal mine dust lung disease. As I've said, when people get these diagnoses, it virtually cuts short their career in any kind of dusty industries. They can't return to any environment where they are at risk of being exposed to dust. And in circumstances where people have been earning some significant income working in the coal mines, that can result in significant financial losses. So judgment was handed down in favour of the plaintiff on the 25th of July this year, and the total of the judgment came to about $3,080,000, which included an award of $750,000 for general damages and some substantial awards for future economic loss, loss of expectation of life, future care and assistance, etc. Now, that damages award is quite significant on a number of fronts, and I'll come to some of those. But I'm going to pause on the general damages point for a moment, because historically, most dust diseases cases that have been heard before the courts have concerned older men, particularly those suffering acute diseases with short life expectancies, such as lung cancers like mesothelioma, severe asbestosis, etc. But in recent years, we've seen a reemergence of pneumoconiosis among younger men, still of working age, particularly in the coal mining, tunneling, and stonemasonry industries. Now, there has not been a lot by way of court judgments to guide how to manage these general damages awards, because the cases are different, where instead of having a very severe but short-term suffering, these men, and they are overwhelmingly often men, suffer for many years, sometimes decades, as Mr. Keogh's case is likely to be, within a period of a very acute suffering in their final weeks and months. And this judgment is really reflective of the fact that the long-term suffering that Mr. Keogh has already suffered and is going to continue suffering, and the fact that his condition is one that is progressive as well, and that is ultimately going to be terminal and is going to take his life. So I have seen some commentary concerning the award for general damages, that it reflects an upward trend of awards in these sorts of cases. In some degrees, I would agree with that. Certainly, we have seen in the DDT generally an increasing trend in general damages in recent years. But what I would suggest is that rather than reflecting an upward trend in general damages in the courts, I think that this is really the courts catching up with the current state of play with these sorts of injuries and reflecting the kinds of general damages award in these different kinds of diseases that we're seeing for these younger men. Now, this claim was one that involved cross-jurisdictional damages. So there was 4 different damages regimes that came into play in this case. There was the Queensland Workers' Compensation damages, Queensland Public Liability damages, New South Wales Public Liability damages, and New South Wales statutory damages for coal miners, which was rather delightfully described by the judge as a dark wood where the straightway was lost. I would take hours to go through all of particularly about the New South Wales statutory damages and the implications of that. That was subject to written submissions, 2 folders of legislation and cases, further written submissions, oral submissions, and further replies after judgment was reserved. So it's a very complex area for New South Wales statutory damages, but what that did result is 4 different potential awards depending on which regime you were working under. And that created quite a bit of a challenge in terms of for the judge in terms of how to deal with that. And it's something that people working in this line of work would be quite familiar with. Cross-jurisdictional claims are quite common in this line of work where there's multiple different damages regimes at play. And I'm going to spend a little bit of time on this because I think the way that it was handled was actually very effective. But before I talk about how the judge actually dealt with attribution, I want to spend a bit of time discussing how a particular niche issue under these different damages regimes that emerges in the workers' comp scheme in Queensland. So the Queensland Workers' Compensation Scheme under the Workers' Compensation and Rehabilitation Act has limitations on care and assistance that can be claimed for workers. And Mr. Keogh was caught by Section 306H. Basically, the crux of the regime is that gratuitous services cannot be claimed. Only paid services can be secured. And this section here, 306H, there was a question over whether Mr. Keogh, having previously received some gratuitous care from his mother, which was not required but was provided while he was living with his mum after the injury, whether that ruled out him claiming any of that care on a commercial basis in the future. So there was little question that most of Mr. or if not all of Mr. Keogh's care in the future is going to be commercial, but he had lived with his mum and she had provided him with some assistance, driving, cooking, etc., etc. Now, nope, sorry, my apologies. Now, ultimately, the parties, the question that was between the parties was whether or not Mr. Keogh could claim for commercial care when some of the care that he had received had already been provided gratuitously. The position of the defendants that was put forward was that on the basis of 306H, the question is a black and white one. Had gratuitous services been provided? If not, if so, then that care is ruled out in any capacity in the future. So Mr. Keogh could not claim for gratuitous driving services, cooking services, cleaning services, etc. The position that was taken by the plaintiff and the one that was ultimately accepted was that the primary consideration is one of need. So did Mr. Keogh need those services when his mother was providing them? And the answer to that was no. He was living with his mum. He was perfectly capable of cooking for himself, driving for himself, etc., etc. But as mums do, mum looked after him, right? That's what mums do. So, and the court ultimately accepted that argument. And I've extracted here at paragraphs 457 and 461, which are some of the critical sections of the judgment that concern this. Ultimately, the judge did decide that the relevant question is one of need, because in order to claim any kind of services, there needs to be a matter of need that's involved in any event. So to reduce it purely to a question of were the services provided, yes or no, is overly restrictive. Now, with all of the complexities attendant upon having multiple different regimes, it obviously creates a significant challenge in demonstrating what's the appropriate award to be made and how to split that up against each defendant. Now, the way that Judge Russell did this was determining the proportion of each defendant's attribution towards the injury, and then doing a calculation on the basis of doing a full calculation of quantum against on the basis of each of the different regimes. So for the Queensland components, 2,915,087, the New South Wales public liability component, 3.232, and for the New South Wales statutory component, the award was 783, but that's actually, that's the reduced award. That's not actually the correct amount. Oh, hang on, go back on. So ultimately what the judge did is took into account the level of exposure at each mine, and basically found that the exposure weighting, as you can see here, was 1 at Poitrel and Morvale, because each of those were found to be the same. Blackwater was 20% dustier and Boggabri was 4%. Then multiplying that by the relative months allowed a percentage to be adopted for their overall contribution to the injury. And those percentages could then be applied to the relative components, to their relative damages awards, which allowed for the awards that you can see in the table at the bottom right of the paragraph. Now, when you go through the judgment, it's all spelled out in quite some detail. So I'm not going to go through all of that, but basically that's the crux of how it was done. And I do think it's I think it's quite an ingenious approach, to be honest. And it's something that I think can be adopted not only in preparation for any future trials that might be done in these sorts of cases, but also in negotiating in any of these claims, because as one can imagine, these sorts of complexities create a lot of difficulty in terms of negotiating claims and identifying relative attribution for various defendants when there are multi-defendant claims, which these sorts of matters do tend to be. And also saying, okay, well, this is your attribution. How do we then work out how much each has to pay with respect to their relative attribution? So it is a process. I'm not going to pretend, even looking at this, that that's a straightforward approach, but it's a good pro forma to be adopted in these sorts of claims. Now, there is a debate that emerged during the course of the trial, both in the giving up expert evidence and in submissions, about the divisibility of Mr. Keogh's coal mine dust lung disease. I could spend an hour or two here going through and explaining all of the relevant principles and the case law. And it is one of those concepts that I think the more time you spend looking at it, the less sense it tends to make. But in sum, the plaintiff contended that disease was indivisible on the basis that the condition once a relative threshold of exposure is attained, that the condition can be caused, and that each exposure therefore made a material contribution to the disease. And critically, that the consequences of the disease were indivisible once the disease had accrued, the damage suffered by Mr. Keogh followed, and he could therefore recover damages in full against each defendant. The defendants contended that the disease was indivisible, as each exposure contributed separately to the condition, and he could therefore only recover from each defendant according to their proportionate contribution to damages. Now, this debate had two very important impacts on the case. The first of which was that if the injury was found to be indivisible, there would have been no need for the apportionment exercise that we've looked at above, and judgment would have had to have been entered against each defendant for the full amount of the claim, and then it would be for the plaintiff to enforce one of those judgments. And it was also relevant to the plaintiff's employment in Western Australia as well, because it was submitted by the defendants that the plaintiff's employment in Western Australia had contributed to his disease, and that to whatever extent it had done so, those periods were not part of the claim and damages could not be awarded. If the injury was indivisible, the WA issue would not feature. Ultimately, the exposure was found to be de minimis, so it wasn't ultimately relevant to the damages consideration in any event, but that was an element of the potential impacts of the argument on divisibility and indivisibility. Now, the classic example in claims such as this of divisibility and indivisibility is mesothelioma and asbestosis. So in a mesothelioma claim, the disease is indivisible, so the plaintiff need only sue on the basis of enough exposure to have caused and materially contributed to the disease. And in asbestosis, each exposure is deemed to cause the condition and to create a worse outcome, so all exposures need to be brought in. That's the classic statement. There was also in the case separate discussion as to whether the psychiatric condition was divisible or indivisible, and ultimately both were found to be divisible diseases. Now, there are a few, I think, quite helpful statements of the principles that can be found in the judgment, and you'll see here I've referred to the paragraphs where divisibility and indivisibility is discussed. I think the most helpful statement of the principles is a statement from Thompson, actually, which was explored in the judgment, which is that what is required in any case of this character is that the tribunal should identify a rational basis on which the harm suffered can be apportioned between a part caused by the employer's wrong and a part which is not so caused. I would emphasize, because the distinction is easily overlooked, that the exercise is concerned not with the divisibility of the causative condition, but with the divisibility of the harm. In other words, the question whether the tribunal can identify, however broadly, a particular part of the suffering which is due to the wrong, not whether it can assess the degree to which caused the harm. So ultimately, as I've said, the condition was found to be divisible, which is quite consistent with the way that the Dust Diseases Tribunal has historically treated these sorts of pneumoconiosis diseases. And so, yeah, that was ultimately the decision that was made by the judge, but it does help provide a very helpful restatement of the principles of divisibility and indivisibility, which are worth visiting for anyone who practices in this space. I want to have a very briefly say something about liability in coal mining claims. And I don't want to say anything too much on this because the decision ultimately turned very strongly on the specific evidence that was given in the claim. And I don't think there's much to be said about broad principles. However, I do think it's important to note that this case turned very strongly on the testimony of the plaintiff and the lay witnesses, and the expert evidence which turned on the statements of the plaintiff and the lay witnesses. There was limited exposure monitoring data in the case, and only a portion of which confirmed breaches of the occupational exposure limits, or even related to the plaintiff. However, that data was not particularly, I'm going to say, reliable, because there was some critical information that wasn't shown in it, and one can't take, it was argued that one cannot take exposure of one worker on one day in one side as being representative of the exposure of another worker. The plaintiff's expert, Carolyn Topping, acknowledged that exposure monitoring or taking samples is an important part of a risk management process, but that in order to be able to rely on that information, you need to be able to back that up with more information, with significant information about the circumstances in which it was taken, including the weather. Was it hot? Was it rainy? Was it windy? Was it dusty? This process of how the samples were taken, the size of the group that the samples were taken in, and they need to have some statistical analysis done to them. It was also, and this is very important, to acknowledge that occupational exposure limits are not a dividing line between what will and won't cause injury. So although the occupational exposure limits are an important regulatory tool, they do not define who will and who won't get sick. And it is expected that even within the occupational exposure limits, if not enough is done to limit the exposure, which it was found to be the case in Mr. Keogh's case, that certain people will get sick. So the thrust of my point in that regard is that the plaintiff's evidence, which was accepted in total, demonstrated an unsafe system of work even without large-scale evidence of breaches of the occupational exposure limit. And that is actually about it. That's the main items that I wanted to canvass in this about this claim. It's very brief, but I hope that it provided some helpful information about litigation in coal mining claims and for people with respiratory injuries sustained in these sorts of industries.
Kathryn, that was really, really interesting and informative. And I want to thank you for presenting that in a way that someone who is not a lawyer, myself, could still understand and follow what you were talking about, and to understand the complexity of how, when it gets down to tin tacks with these matters, what is actually discussed. And I get the feeling too that from your point of view in analysing this matter and presenting it to us, that nevertheless, in spite of the fact that it actually got down to some legal points of argument and terminology, that actually at the whole time, the fact that an injured person was at the core of this matter remained very much the focus.
Yes, certainly that was our focus in representing
Yeah.
Mr. Keogh, was that there was a person with this disease, and it didn't happen by accident.
No, absolutely. And as you said, a man who loved his job, who knew the risks, but loved what he did, derived a great amount of satisfaction from that role.
Yeah, yeah.
Yeah.
Sorry, I should clarify, not that it didn't happen by accident. I'm not suggesting that anyone deliberately gave it to him, more that it
Oh
doesn't
gosh, no.
happen, absent an exposure is more what I was getting to.
Absolutely. No, I understood that. Understood. Look, everybody, if you would like to unmute yourself and ask any questions of Kathryn, now would be the time to do so. All right. I have one question from somebody who has been unable to attend today.
Mhm.
And they wanted to know a little bit more about, oh, here we go. A person is saying here, Roger says, you articulated complex issues in a very compelling way. So again, thank you very much, Kathryn. The question that I have is from a person who was unable to attend, and they just wondered if you could elaborate a little bit more on how, when you're preparing a matter such as this, how you determine where you're going to be leaning in terms of apportioning the damage. And as you said, this gentleman worked at 4 different mine sites across different states and jurisdictions. So they just wanted a little bit more about that.
Yeah. So ultimately, the exercise that we went through was very similar to what the judge put forward. So we went through it's actually for the defendants to deal with apportionment between themselves, but when it's scuppering negotiations, sometimes it can be for the plaintiff to become involved. And for the purposes of the trial, we did prepare an apportionment, our view as to the apportionment, which is reflected in that judgment. So it's a challenging thing to go through and identify that, but I think that the way that it was done in the judgment is basically reflective of the exercise that we went through.
Great. Look, that really was terrific. And often when there are no questions and only one compliment, it's because of how well you presented. And again, that was really terrific, really excellent. I would like to thank you so much for your time and for the effort you put into sharing this with us and educating us on this really important issue. Thank you to everyone else who joined us, and we look forward to seeing you at our future seminars. Thank you again, Kathryn. Have a wonderful rest of the day.
Thank you, Michelle. Thank you, everyone, for listening.
Bye. Now let's stop that recording.